Vogel versus Northeast Ohio Media Group LLC et al.
But there's
Are we waiting for someone else?
there's a second Kelly. He may be on
All right, that's
I
fine.
can
We're early. We're good. We can wait.
give me 1 minute.
Go ahead and get your, take your places. We gotta go on up. Okay, we're good.
Oh,
Or
good.
not.
All right, we have everyone.
We got everything here? All right, I'm gonna call the case again, since everyone's here, Stephen Vogel versus Northeast Ohio Media Group. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes. Before you begin, let me know if you wish to reserve time and how much. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up and remain behind the podium. We have read your briefs and we are ready to begin when you are.
Thank you. I would like to reserve 2 minutes for you. May it please the court, my name is Mark Owens. I'm the attorney representing the appellant, Steve Vogel. In accordance with the savings statute, plain language of 28 U.S.C. 1367D, and the U.S. Supreme Court's recent 2018 decision in the Artist versus District of Columbia, Mr. Vogel's state claims for libel and defamation were not, quote, expired, end quote, at the time that he refiled them in federal court, such that he could take advantage of the 30-day provision in 1367D to refile in the state court after the federal court had dismissed the state claims without prejudice, essentially deciding not to exercise supplemental jurisdiction. Now, I was going to argue to this court that this is a case of first impression in Ohio. However, this court has actually dealt with this issue already. Another case that our office is involved with, on April 8th, 2019, this court entered a journal entry in the case State of Ohio XREL Consume Food Industries, Inc. versus the Honorable James Morality et al., and that's a 9th District case number 19CA000359. That case was very, very similar to this one. It's a sex discrimination case. It had been filed in the Lorain County Court of Common Pleas. It then was voluntarily dismissed. Those claims were brought along with some federal claims in federal court. The federal court dismissed the federal claims and decided not to exercise supplemental jurisdiction over the state law discrimination claims. And then within that 30-day window in 1367D, the plaintiff refiled in the Lorain County Court of Common Pleas. And the counsel for Consume argued, as the media parties are arguing in this case, that it was beyond the period that they could refile the claims in state court. He argued that it had been 4 months past the 1 year under the Ohio savings statute by the time that the case was refiled in state court, and this court said no, that it was not untimely. This court held in that case that the savings statute applies to allow a refiled complaint to, quote, stay within, end quote, the statute of limitations, which is exactly what our argument is here. What Artis held was to toll means to hold in advance or to stop the clock. What the trial court held, and what's being argued by my adversaries here, is that there was no clock. Because the Ohio savings statute was used to refile, their argument is it was already expired when you filed in federal court. Our argument is no, and I think this court's decision in the Morality case supports that as well. This court further stated in that Morality opinion that the savings statute creates, in essence, another period of time in which the plaintiff may refile a claim that would otherwise be time barred. And It's citing to periodical distribution versus Bismarck, an Ohio Supreme Court case, 95 Ohio State 3rd, 452. The court also noted that the Ohio Supreme Court has concluded that the expiration of a statute of limitations does not deprive a court of jurisdiction, because to hold otherwise would elevate the statute of limitation to the status of a subject matter jurisdiction defense. So just as this case held in Raleigh, the Ohio savings statute does allow a claim to stay within the statute of limitations for purposes of refiling. And if it was a valid claim when filed in the federal court, then 1367D allows 30 days from the time of dismissal for that state claim to be refiled in the state court. Now, it's been argued by the other side that this violates the two dismissal rule. And their argument is that the Ohio savings statute is actually being used twice. And that is not true. The Ohio savings statute was used the first time to refile in federal court. 1367D's 30-day provision is being used for the second filing in the state court. So that does not violate the two dismissal rule. The savings statute is not used twice. Ohio courts have long understood that 28 U.S.C. 1367D provides at least that 30-day period for refiling of any claims dismissed in the federal action, any state claims rather. In a case that was decided 2 years prior to Artis, the 4th Appellate District faced the same issue in Williamson versus Scioto Township treasurers, or trustees rather, and that's a 2017-Ohio-1099 citation. In that case, the plaintiff failed to utilize 1367D to refile his claims within the 30 days in state court, and the Williamson court held that having already utilized the Ohio savings statute, the plaintiff could only avail himself of the additional 30-day federal tolling period provided by 1367. And it further stated, absent a remand order, in our view, Williamson would have had to refile, not reinstate his claims in the state court. He would have had to do it within the 30 days, in light of the fact that he had already used the Ohio savings statute once. That's exactly what has happened in this case. The Supreme Court's decision in Artis does not change that interpretation at all. Again, Artis simply held that to toll the limitations period means to hold it in advance or to stop the clock. Here, there was a clock provided by the Ohio savings statute. It provided an additional year to file the claim. It was valid when filed in the federal court, therefore, the 30-day provision of 1367D would kick in and would apply. From a policy standpoint, the trial court's interpretation of Artis leads to an unfair and discriminatory treatment of Ohio plaintiffs in federal court based on the relative lengths of statutes and limitations of the asserted claims. If we follow the trial court's interpretation, any plaintiff who decides after voluntarily dismissing their case in state court, if they decide they then want to try the federal forum and they also have some federal claims they want to assert, if they do that, utilizing the savings statute, if we follow the trial court's logic, they do that at their own peril, but that they may never have their state claims heard on the merits. Because according to the trial court and according to the immediate defendants in this case, if you use the savings statute to file in federal court, that's it if the federal court decides not to exercise supplemental jurisdiction. And we believe that that's absolutely contrary to the intent and spirit of the rules. The way that we presented the tolling provision in 1367D and the interplay with the Ohio savings statute, we believe promotes fair and efficient operation of the federal courts. And it's even been recognized, actually in Artis itself, at page 605 of the Artis decision was recognized that 1367D provides an option to federal judges when they're debating whether to retain jurisdiction over supplemental state law claims that might be time-barred in state court. And it discourages plaintiffs from simultaneously litigating federal and state claims that would arise from the same episode in both federal and state forums. That really was the concern in Artis, such that you couldn't just have these claims go on forever. When you have a one-year statute of limitations, like for libel, for example, and for defamation, it's highly likely that by the time a case is voluntarily dismissed, that one-year statute would have expired, and the plaintiff would be using the Ohio savings statute. This court should, and I think it's consistent with the Raldi decision, should provide Ohio plaintiffs with the maximum opportunity to pursue their state law claims. Not indefinite opportunity, of course, but just the maximum opportunity that's provided by the savings statute and by federal statute 1367D. It's only a 30-day window. I know the argument's been made by the other side, there needs to be a finality, you can't just keep these claims going forever. It's a 30-day window if the federal court decides not to hear those state law claims. So it's a very short period of time. And it does give Ohio plaintiffs the opportunity to pursue their state law claims without penalty for having decided to file in federal court. And unless the court has any questions, I mean, it's a very narrow legal issue. That's basically it in a nutshell. Thank you very much.
Are you guys going to be splitting your time in any way?
I'll give him some time to the extent he needs it.
Your Honors, because our positions are so aligned, well, we'll defer to Mr. Kaporis' argument in the interest of efficiency. Thank you.
Good morning. Please the court. My name is Dan Kaporis. I'm here on behalf of appellees, the Advance Ohio, formerly known as Northeast Ohio Media Group, and the Plain Dealer. And I too will keep this as brief as possible, subject to the court's questions. Mr. Owen's main argument this morning has been that Vogel's claims were not expired at the time he filed his second lawsuit in federal court. And because that's the case, Section 1367 gives him the right to refile those unexpired claims within 30 days of the dismissal, the federal dismissal. But that's not the issue for purposes of 1367. The issue is not whether the claims themselves are valid or considered timely, which in this case they were, due to the Ohio savings statute. 1367, as the Supreme Court made clear in Artis, its only function is to toll an existing statute of limitations for the period of the federal case and for 30 days after the dismissal of the federal case. Here, there was no statute of limitations period left to toll. The statute of limitations had expired years earlier. The sole reason Mr. Vogel was able to bring a timely claim in federal court was the Ohio savings statute. And the Ohio savings statute is not itself a statute of limitations, nor is it a tolling provision that extends the other statutes of limitations for the cases that have been dismissed. The Ohio Supreme Court has actually said as much in the Allen versus McBride case, which I believe is 105 Ohio State 3rd 21. Again, that the Ohio savings statute is not a statute of limitations and is not a tolling provision that extends the statute of limitations. So once the statute of limitations expires, there's no work left for Section 1367 to do. It can't toll anything, and even if it could theoretically toll the 1-year period under the savings statute itself, that's where the two dismissal rule comes in to bar Mr. Vogel's claims. He can't then pick up after using the savings statute once, claim that that 1 year refiling period had been told, and then use it a second time to refile this case. Going to the Moraldi decision by this court, Mr. Owens argued that the court had already addressed this issue in Moraldi and had found in favor of his client. That's not actually the case. The only issue that this court dealt with in Moraldi was whether it was appropriate to bring a writ of prohibition against Judge Moraldi to prevent him from continuing a case in which he had denied a motion to dismiss based on the statute of limitations, and this court said that that was not the appropriate vehicle to challenge it. The appropriate vehicle would be an appeal because statute of limitations, whether Judge Moraldi was right or wrong on that issue, wouldn't create a question of subject matter jurisdiction, which is the purpose of the writ of prohibition. That's the only issue that was in front of the court or decided by the court in that Moraldi decision. Mr. Owens also mentioned the Williamson case. Two things about that case that are distinguishable. The first being that the comments about the 30-day period in 1367 were purely dicta. As Mr. Owens mentioned, the plaintiff in Williamson failed to refile his dismissed claims within 30 days, so the issue of whether he could was moot at that point. But in any event, the Williamson case was decided pre-Artis. So any commentary in Williamson that suggested that 1367 creates a 30-day grace period to refile claims was conclusively overruled by Artis. Artis considered two interpretations of 1367. One was the 30-day grace period interpretation. The other was the tolling interpretation, and it decided against the 30-day grace period interpretation. And in fact, specifically called out situations like this one, where a plaintiff files an expired state law claim in federal court, has that claim dismissed, and then is able to refile it under a 30-day grace period as timely. So basically using the federal courts as a mechanism to revive stale claims, and said that that would be an absurd interpretation of the statute. And the court specifically rejected it.
Of course this wasn't a stale claim.
I apologize?
I said, of course this wasn't a stale claim.
A stale claim, it was, that's a little imprecise. It was not stale because it was timely under the savings statute, but the statute of limitations itself had expired. And what the court said in Artis is, we read the plain language of this statute to say that it is a tolling provision for statutes of limitations. If there is no statute of limitations, there is no tolling. And 1367 doesn't perform any function, which is the case here.
Of course that nullifies Ohio's savings statute.
I'm
That
sorry.
would nullify Ohio's savings statute, obviously.
It would nullify it. I'm not sure what you mean by that.
That's it. I'm sorry. What I'm saying is that would nullify Ohio's savings statute because you would have that remedy in the in Ohio state courts, but the federal court elected not to take jurisdiction and didn't do anything with it. But then you can't refile in the state court, even though the Ohio savings statute, even though Ohio law says you can.
Well, Ohio law says you can't, actually. In this case, Ohio law would say you cannot refile under the savings statute for this third time. So I'm not sure I agree that it would nullify the savings statute. Mr. Vogel was able to use the savings statute the one time to refile in federal court. That's exactly what it's designed for. It's designed to provide a one-time exception to a statute of limitations that has expired while a claim has been pending, which is what happened here. The savings statute says, look, you get one shot to refile your claim. Mr. Vogel took that shot in federal court. If the claim gets dismissed a second time, you can't then use the savings statute again. So nothing about the way that 1367 operates here affects the Ohio saving statute. It performed its function, and Mr. Vogel is not arguing that it should save his claim here either, that he should be permitted to file his claim pursuant to the saving statute. His claim is that section 1367 gives him an independent right to file this untimely claim. And our position is that the statute does not allow that, where the original claim was filed after the statute of limitations had already expired, because it's only, again, 1367's language, its only function is to toll a statute of limitations. It says nothing about, extending additional state law exceptions to saving statute, or to statute of limitations, which is what the saving statute is and what it did here. Just briefly, as to the fairness issue, and I think this comes back a little bit to your question about how the two statutes work together. A plaintiff who refiles a case a second time using the saving statute risks dismissal no matter where that case is filed. There may be additional hurdles in federal court, certainly, given the limited subject matter jurisdiction and other issues. But at the end of the day, and this is something that Judge Collier recognized in his opinion below, it was the plaintiff's strategic decisions about where to file his case, whether to voluntarily dismiss his case, file it in a new court, in a federal court, that led him to this point. He just as easily could have filed his case for the second time in an Ohio state court, and where the risk of a dismissal for lack of subject matter jurisdiction would have been less. He would have risked dismissal for other reasons, other Rule 12 reasons, what have you.
So filed his state action and filed his federal action separately.
He could have done that. He could have filed all of his claims in state court. He could have done either one. But his rule, his proposed rule, would allow a plaintiff to simply cook up a federal claim, file an expired claim in federal court, and then get a dismissal, which he knew was coming, only to preserve the timeliness of his state law claims that otherwise would be expired and for which he could not otherwise use the Ohio saving statute.
What would be the point of that if you would just go and file in state court? If you have a manufactured claim in federal court, what would be the point of manufacturing a claim to get in federal court to try to save the saving statute, which you already had the right to file in state court?
So, for example, if the plaintiff filed his second action in state court, decided for whatever reason to voluntarily dismiss that case, right? So at that point, the Ohio saving statute is off the table. He's already used his one-time exception. He could then proceed to federal court, file a bogus federal claim alongside his state law claims, get the whole thing dismissed, and then invoke 1367 to file, that would be the fourth case, in an Ohio state court, at which point he would say, well, Your Honors, under 1367, I have 30 days to refile my state law claims, and they're timely regardless of what the timeliness of those claims when I filed them in federal court. And so that kind of sort of perpetual bouncing back and forth between the courts is what both 1367 statutes of limitations and the Ohio saving statute work together to prevent. And we'd ask the court to adhere to that rule and adhere to the clear precedent set by Artis, this court with respect to the due dismissal rule, and hold that plaintiff's claims are untimely. If there are further questions, I'm happy to answer them. Otherwise, Dan, if you'd like to take what's left of the time, or
Your Honor, Dan Eisenbright on behalf of the City of Medina, Tamika Morris, and Susan Haley Mazzaro. As I stated before, because our positions are aligned, and as we see this issue has already been decided by the U.S. Supreme Court in the Artis case, unless the court has any questions specific to the Medina defendant's position, then we will ask the court to affirm. Thank you.
Thank you.
Carr touched on, the Artis case did not involve an Ohio, well, or any state savings statute. That was not something that was part of that opinion or part of their analysis. So the issue of how a state savings statute interplays with 1367D is not an issue that Artis analyzed at all, which is why we've indicated that this really is a novel issue in Ohio. It was also mentioned that the savings statute prevents a second filing in state court. The purpose of the savings statute is obviously you can only use it one time. So you could not use the savings statute 2 times to file in state court. It does not prevent the savings statute from being used once to refile a state claim as part of pendent claims in federal court, and then being able to use a separate statute, which is 1367D, to refile in state court. The analogy that we heard doesn't work. It was suggested that you could dismiss your state court claim using the savings statute and refile it, that you could do this twice and having filed 2 or 3 times, still be able to go to federal court. That is not the case. If you've already used the savings statute twice, there would be nothing left. There would be no way you could even get it to federal court. So I don't think that analogy works at all. The claim was not untimely. The state law claims were not untimely when they were filed in federal court. They were timely in accordance with the savings statute, and they were valid claims when they were filed. They were not expired claims. And I believe that that's the important distinction and the important issue in this case. Unless the court has any questions, I would wrap up my argument. Thank you very much.
Thank you both for your presentations. We will take the matter under advisement.